May I be permitted to mention one specially assigned matter? This matter that heard the petition is
Civil revision.
revision matter.
Yes.
Applications for incorrect.
Give it.
Again, mention for the
Why not for mentioning for the
Yes.
list?
Mentioning for what heading?
Inclusion of list.
Inclusion for which case?
For FMA 1114 MSCC
MSCC. Yes.
1144 of 2025
Yes. Yes. Please.
and 2879 of 13.
My lord, may I be permitted?
My lord,
Oh.
the urgency is, my lord, the 24th is fixed for framing of charge, my lord.
No. Is it a case of NI Act?
My lord.
No. Other than NI Act, you see, other than NI Act, this court is not conferred with the determination. Only you see the list.
My lord, prime
Heading.
instrument and NIA.
So mention before the other bench, which is conferred with the determination.
My lord, may I be permitted to mention extension of interim order?
Extension of interim order regarding which case?
The case interim order expire. It will
No. Before the determination of this bench?
no, my lord.
Of Justice Sharma?
Justice Dinesh Kumar.
No. Is it with regard to Negotiable Instrument Act or some other matter? You see, unless it is with regard to NI Act, this court does not
Yes,
have
my lord.
determination. What Act? NI Act?
NIA.
Yes. Then you give the slip.
May I be
NI Act criminal division determination to my lord Justice Dinesh Kumar Sharma.
NI Act?
NI Act.
Yes.
May I be permitted to mention, my lord? It is I'm for the appellant and modification of the order dated 29th July 2025. Honorable Justice Ananya Bandyopadhyay. It is very urgent, my lord. Kindly include
No. Modification of this order?
order
no, no.
execution proceedings.
No. If it is modification, mention before her ladyship how this court will have the determination. Matter, the judgment is passed by her ladyship. So any modification matter you mention before her ladyship. Because this court cannot take any modification or
Correction, my lord. Correction.
no. It's better you
Correction.
No. You better you mention before her ladyship. If her ladyship directs you to mention, then I shall consider. Because it's the judgment is passed by her ladyship. It's better to make the
Also passed, my lord.
no. Judgment is passed. So any correction, it is better to do it before her ladyship. So mention the matter there first.
Mention, I'm for the appellant, insurance company.
No. Question is you want a rectification of the order.
Rectification of the order.
Because the judgment is passed by Justice Bandyopadhyay, you mention the matter before her ladyship for correction by her ladyship. Because this court cannot correct the order passed by another learned judge. So mention there.
My
lord.
My lord, stay application.
Yes, please.
My lord, permitted to mention, my lord, two applications.
Application in claim case.
Claim case matter.
Yes.
And one matter for hearing, my lord.
Hearing of claim case.
Yes.
Yes.
My lord,
may I permitted to mention
inclusion, claim case for inclusion and
Yes.
one for to be mentioned. One claim case for to be mentioned.
my lord new motion.
Yes.
I am mentioning for inclusion, my lord.
Inclusion of what case?
New motion.
New motion.
CRR.
Yes.
My lord,
CRR.
5 cases.
New motion means what? New motion of what? Revisional jurisdiction
Revisional jurisdiction.
of Justice Sharma.
It's a claim cases. It is
Yes, my lord.
No. Is it with regard to Negotiable Instruments Act?
Yes,
You-
my lord.
you-
No, I said that.
No. Anyway, let it appear as to be mentioned. Thereafter I shall see. Yes, give the slip.
I would like to mention with the claim case hearing on application.
Yes, give the slip.
Extension of interim order.
Yes.
Extension of interim order.
Yes, a interim order passed by whom? Is it a criminal revision matter?
My lord, I don't know.
No. What is the nature of the case? Claim case or what case?
Second appeal.
Okay, second appeal.
Yes, my lord.
Extension of interim order. Yes, please give the slip.
Not CRR, my lord, inclusion new motion.
Yes.
Inclusion new motion, madam.
Inclusion of new motion. Of whose determination?
Justice Sharma.
Justice Sharma, is it with regard to NI Act? Yes, give the slip.
Number one.
I am appearing on behalf of the respondent insurance company. One Mr. Uday Shankar Chatterjee is appearing on behalf of the appellant.
So paper books have been filed.
I have received a copy. Probably he was supposed to probably say that he'll be filing. My lord will pass it over for a little while. If he comes,
Pass
he
it
comes.
over, I can
Otherwise,
make it not today.
my lord.
Okay, not today.
My lord. Great.
Item number two, Lordships, I am for the appellant petitioner. Lordships, this matter already disposed of. And Lordships,
No, disposed of by this bench, by me.
Lordship, this is not the otherwise correction. Check also issued by the,
Yes.
as per order of Honorable Court, the issues of Lordships, Justice Bibhas Ranjan De, the order was passed.
Yes.
But Lordship, fact is that here claimant are parents and wife. Parents already received withdraw check and that has been satisfied. But Lordship's wife withdraw the check, but when Lordship deposited in bank, that time not disbursed because Lordship his
No, validity period is over.
yes, Lordship.
Is the validity period of the check is over?
This is not the case, Lordship. Now Reserve Bank Lordship rules change. Her name was Lordship Dipti Sequal Sharma. He was married on Probin Sharma. That's why his name written in Dipti Sequal Sharma.
So for that, have you taken out these two applications?
Yes, Lordship.
This can two.
Can two. Can three, can two, same. Can two is Lordship's misplaced somehow. That's why again can three file. Your Lordship, before your Lordship, can three.
See, other side is not here.
It's other side, Lordship already one time order passed, but somehow some mistakes. Honorable Justice Honorable Bandyopadhyay stated, please enclose the.
Let me see just. What is your
Already
application? What is your application for?
order.
No, what is your application for?
Application for appropriate order, Lordships. Check will be issued instead of Lordship Dipti Sequal Sharma. Only Dipti Sequal. And as per Lordship's bank account and also Aadhaar card. As per Aadhaar card.
The claimant was Dipti Shikwal.
Yes, Lordship.
Okay. Now, claimant is Dipti Shikwal, but the claim was awarded in favor of the claimant Dipti Sharma.
Dipti Sequal Sharma.
But you have
and check also Lordship Dipti Sequal Sharma. But
Dipti Shikwal Sharma.
yes.
Check is issued in the name of Dipti Shikwal Sharma. But your bank account is the name of Dipti Shikwal.
Sequal as per Aadhaar card. Lordship now the Reserve Bank Lordship's rules.
No, it na. We rectification to judgment na. Check awarded ব্যাপার judgment তো ঠিকই আছে. So let the other side come, okay? You just need it.
I think Gopa Mukherjee will come, Lordship, pass over in the minute.
Okay, I'm passing it over.
Lordship, grateful. And also Saidur Rahman also there.
এটা কারেকশনের জন্য আছে না? এটা মানে কারেকশনের জন্য আছে মনে হয় নাকি? অর্ডারটা রেকর্ড হয়নি, তাহলে অর্ডারটা রেকর্ড হোক। হ্যাঁ,
কিন্তু এখানে একটু অর্ডার দিলে
তাহলে কি সিম্পলিসিটা নট টুডে করে দিই নাকি? আগের অর্ডারটা কি রেকর্ড হয়নি, সার্ভার হয়নি? তাহলে এটা করলে লেট দিস ম্যাটার। ইউ আর ফর? আই এম ফর দ্য রেসপন্ডেন্ট ইন্স্যুরেন্স কোম্পানি। Respondent Insurance Company. No, item number 4. 3. Yes, you are for the Respondent Insurance Company. Now the question is, matter is ready for hearing.
Paper book file
You are for the appellant.
Mr. Roy is there, my lord.
So let it appear.
Not the hearing matter.
As the learned advocates for the parties are present, as the matter is ready for hearing and the paper books have been filed, let it appear for hearing on 9/12/2025.
Four, I am appearing on behalf of the appellant insurance company, my lord.
On prosecution.
Yes, it's non-prosecution. The awarded sum has been taken away through execution by the claimants. I have received instructions from my client, my lord, to withdraw the appeal. This is the written instructions, the email.
Yes, record an order.
And my lord will also grant me leave to withdraw the entire deposited amount from this honorable court because money they have already taken away.
The other side is not here.
No, they won't appear because they've already received the amount.
Learned advocates for the appellant is present. It is submitted by learned advocate for the appellant that the appellant does not intend to proceed with this instant appeal on the ground that the awarded sum has already been withdrawn by the claimant respondent from the trial court by filing execution case. Stop. Learned advocate submits that she has instruction not to proceed with this instant appeal. Thus, this appeal stands dismissed for non-prosecution. Stop. The sum deposited by the appellant insurance company is permitted to be withdrawn upon compliance of all the requisite formalities. Let the copy of the instruction filed by the learned advocate for the appellant be kept with the record. This appeal stands disposed.
My lord, my lord had directed shall be allowed to be withdrawn by the appellant, my lord, kindly. That by the appellant.
Amount deposited by the appellant insurance company may be withdrawn by the appellant
My
on
lord,
compliance of all the requisite
My lord,
formalities.
deeply obliged, my lord, grateful.
Yes, my lord, in this appeal, my lord, I am for the respondent claimants. My lord, respondent claimant is a higher.
So
high
there is a
official.
counter appeal also.
Yes, at our instance. My lord, the dispute with regard to, my lord, the deduction of the, my lord, the professional tax. So, my lord, kindly see the paper book. No, আমি বলে দিচ্ছি. Kindly see the paper book at page 30.
Page
Page 30. This is the 3
the
months.
matter was hard.
Matter was hard at that almost completed, my lord.
Okay.
My lord, one thing, my lord, page 30.
Yes.
There are 3 pay slips of the disease. My lord, that is, disease was a high official of a railway employee. Now, my lord, your lordship kindly see the first portion. My lord, the gross income is 52. My lord, the left hand side top.
Yes, page 30.
Page 30.
Yes.
And my lord, here the professional tax right hand side, it was deducted, my lord, 200. Tax. Professional tax. Your lordship kindly see the second column, top. That is the, my lord, the pay slip of December 2016.
Yes, professional tax.
Now, my lord, the middle portion.
Yes.
Is a, my lord, pay slip of January 2017.
Yes.
My lord, the gross income is 52,000. Here, the professional tax amounts to 150.
Yes.
Your lordship kindly see last column in the second 150. Now, my lord, in the bottom, it is a pay slip of, my lord, February 2017.
Yes.
Here, professional tax is 200. My lord, dispute is with regard to 200 and 150.
So the learned trial court took into consideration which one, 200 or 150?
No, learned tribunal considered, my lord, 48,000. that is much below, my lord, 52,000. That's why, my lord,
What is the income tax deduction here?
income tax deduction here is, my lord, that was also, my lord, report was submitted by the railway authority.
Regarding income tax deduction.
Deductions.
So that was taken into consideration.
Yes, that was, my lord, that they, as per their key order.
ওখানে কিছু ট্রায়াল করতে দেয়নি
My lord, this honorable court, her lordship, the honorable justice Anurna Bandyopadhyay, desire directing the railway authority to submit, my lord, the instructions to submit the report regarding the, my lord, the income tax deductions. Now, my lord, report was submitted last occasion. Report says, as per the railway
ইনফরমেশন সিস্টেম
information system, tax was deducted.
What was the quantum of tax?
No, there is no mention. That was deducted the railway authority. Because
System
under the
there.
railway, my lord, there are, my lord, the thousands of railway employees. As per their system, my lord, they, my lord, pay the income tax, my lord, amount to the, my lord, the income tax department. Now, my lord, her lordship was not satisfied before. Now, my lord, thereafter, my lord, her lordships by order dated, your lordship kindly see,
25th সেপ্টেম্বর
25th September 2025. Kindly
Yes, let me see the order. Hey, order sheet ta din.
সেপ্টেম্বর
25th September 2025. My lord, her lordships, my lord, desire, my lord, to appoint Mr. Sukumar Bhattacharya, who generally, my lord, he is present, my lord. Sukumar Bhattacharya represents the Railway Eastern, is represented to instruct the Chief Office Superintendent Eastern Railway working in pay bill section who had appeared before the learned tribunal admins in the civil court. My lord, in the first occasions, my lord, the matter was remanded to the trial for the further evidence regarding the income tax deductions and the, my lord, the professional tax deductions, everything. My lord, the income tax department appeared and clear everything. Even after that, our lordship desire by directing further the railway authority. Koi order ta koi? বের করো। Yes.
এখানটা অর্ডারিং
Your lordship kindly see the ordering portion. Learned advocate Mr. Sukumar Bhattacharya appointed be regularized by the competent authority. The concerned authority is therefore to place before this court on an affidavit the Form 16 issued in favor of the deceased victim as aforesaid for the assessment year of 2016 and 17 or the salary slips of the entire period commencing from month January 2016 to November 16. Next date fixed on 26 November 2025. My lord, if my lord,
So the matter is to be taken up on 26 November 2025. But the matter is heard prior to that date.
অল পার্টিজ আর প্রেজেন্ট
all parties are present, my lord. Mr.
Anyway,
Sukumar
but
Bhattacharya,
that report and that affidavit is to be taken into consideration.
my
Thereafter,
lord, the affidavit is required, my lord.
no, you see, when a court has directed,
My
it has to be.
We consider that 20
No.
be deducted.
You see, let us get a picture. When an order of the court is there, that has to be seen.
All right, your
Anyway, I am
lordship-
granting them opportunity to file it. If they have not
my
filed
lord,
it,
your lordship kindly fix the matter on.
anyway, after 2
26.
weeks or something like that.
No, 26, which was date fixed for.
I tell you, Lordship, we have not yet regularized our appointment. It will take some time.
Order.
GM law.
Anyway, that can be done, but in the meantime, you file this affidavit.
Yes, they provide me.
The matter was-
Regularize, my appointment is regularized, they will not hand over any. Your lordship kindly
The order
assure
was
that
passed on
well,
25th
3 weeks,
September
your lordship assured,
2025.
in the
Enough
meantime, I
time is
hope that
given.
everything will be completed, even the affidavit also.
25th September 2025, last order was passed, and today is.
So you have communicated that order also. Now you follow it up.
I shall.
So today or tomorrow, this appointment will be regularized. Okay.
But so far the documents and affidavit is concerned, unless I get it, I can't place before the lordship.
My lord, 3 months, my lord, my learned friend has already received.
Yes, record an order.
May I leave, madam?
Yes, I am fixing a particular date. You see, you will take how long? 3 weeks. So today is
My lord, kindly make it 2 weeks.
21,
Because
28.
the lady, my lord, who lost her, my lord, the bed earner.
My lord, your lordship, my lord, this is my appeal. My lord, my learned friend has taken a lot of time.
Appeal, my lord, he has considered that the grounds taken.
My lord, the aspersion is being cast against the court. Wrong submissions are being made.
What is the order that has to be complied, you see?
Yes, yes.
This is, the authorities are bound by this order. You see, today is 21. Anyway, I'm keeping it on 9th.
Your lordship, I paid for 3 weeks now, if your lordship.
9th or 10th. Because you see, thereafter 2 weeks, this bench will not sit. So then I have to keep it in the month of January.
No, January is my lord.
It's very
Oh,
good.
because you see,
Hard at-
yes, learned advocates for the parties are present as directed by this honorable, by learned coordinate bench of this court on 25/9/2025, that the railway authorities shall submit an affidavit in the form number 16 issued in favor of the deceased victim on or before 26 November 2025, and the learned counsel appearing for the railway authority submits that some more time is required. This matter is fixed or let matter be fixed on 9/12/2025. Okay, 10/12/2025, and the said affidavit shall be submitted on the said date fixed without fail.
That is your lordship's order. No, I will communicate your lordship's order.
The
That is
matter
what
should appear.
lordship had 3 weeks time.
My lord, dispute is with regard to deduction.
No, it was due to be submitted on 26th.
Because railway was not party, that is the difficulty. That is why we have to go through the record, we have to fix whether whether it can be engaged or
A
not.
copy of this order be communicated to the railway authority
By my
Yes.
communication.
and a copy of the claim, copy of this memo of appeal be also furnished.
No paper has been
Memo appeal to ওরা দেবে।
no documents have been
আমরা তো
provided
এটি
to us.
করছি। মানে paper book prepared by my learned friend।
Okay, a copy of the order be communicated.
আমরা করেছি।
But it will be difficult for the railway authority to ascertain who is this victim and all these things. Okay.
No, the railway authority already disposed before the tribunal.
Few months back.
Malari, few months back.
Okay, let a copy of the claim, a copy of the memo of appeal be submitted to the railway authority
By the
appellant or the respondent.
by the
Your
applicant
learned
on-
friend will not have the copy, so either you or Mr. Singh supply him the copy. You give it to your learned friend, he will do the needful.
All right.
I have already done.
Otherwise, it will be difficult for them to get the picture unless they go through the claim petition or the
Copy of memorandum of appeal.
memorandum of appeal and that claim petition.
Here in the paper book,
Very well, very well.
kindly record, Bala.
Yes, the learned advocate for the railway authority is handed over the paper book comprising the memo of appeal and the claim petition. Then only they will get a picture. Yes. Yes, yes.
Matter is similar in the year 2000.
Otherwise, I can do one thing. I can appoint a special officer from this court to go and collect that if they have some difficulty.
Let us come back on 10th, Malad, if it is done with it.
Otherwise, that has to be done.
Remind your lordship, of the.
That point was raised by learned friend, whether 150 or 200, what should be the income?
Yes, it is. Unless they get the entire copies, it is very difficult to get the picture. Whose salary and all these things. Anyway,
Order number 7.
Sir, I am for the petitioner in this matter. For the interim order which has been passed.
oh, this is Justice Sharma's determination.
Yes,
First of all, whether it is an NI Act matter?
yes, yes.
Yes.
My lord, the interim order which has been passed on my lord last occasion on my lord 5th August 2025. That was expired after 2 weeks after the puja vacation. My lord, during this time I have filed this CRAN application.
That is CRAN 4.
CRAN 6, my lord. Your lordship got it? Your lordship may take my copy. CRAN 6 to name.
CRAN 6 টা কোথায় গেল? সবার উপরে? Oh. Oh, this is for extension of interim order.
Yes, ma'am, only. Interim order is expired 2 weeks after puja vacation. Your lordship kindly come to the page 8 of the CRAN 6.
Okay.
Lord, first interim order on passed on.
Yes,
9th.
record an order. Learned advocate for the petitioner is present. This is an application for extension of interim order. In terms of order dated 5/8/2025, this interim order has expired on 7/11/2025. Upon considering the petition and upon hearing the learned advocates, this interim order
Lord, let it be until further. Otherwise, my lord,
stands extended for a period of 5 weeks from date or till further order, whichever is earlier.
let it be until further. Because my lord, I cannot hear it out on my lord. What happens, my lord?
Obtain an extension before the from the regular bench.
This is the 6th time I am praying for extension of India with the application, because now in the criminal jurisdiction, each and every time whenever we extend the interim order, even within the time, my lord, we have to file an extension of interim order. That is the main difficulty.
You have made it 5 weeks from date.
My lord, let it be then, my lord, for 3 months, because my lord, date is, my lord, 1st
Okay,
December.
India stands extended for a period of 1 week from the date of reopening after Christmas vacation.
Or my lord, let it be 2 weeks.
No,
My
no.
lord, I am not bargaining with the court, my lord, because my lord,
1 week is sufficient. You see, 1 month time is sufficient.
my lord, 1 week, my lord, we cannot hear it out, my lord.
আচ্ছা,
That is
ছেড়ে
the
দে, 2
main.
weeks করে দিই। No, 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 no. I think, yes, this application for extension of interim order
Is to be
sta-
disposed of.
stands
That is
disposed.
to be disposed of.
Right.
2 weeks after reopening of
2
the.
weeks after reopening, 2 weeks from the date of reopening after Christmas vacation.
Exactly, my lord. And my lord, your lordship kindly fix the matter in the regular bench any day, because
No,
my
no,
lord,
no, no, you mentioned.
otherwise, my lord, this matter cannot be heard, and my
You
lord,
obtain extension if the matter cannot be heard.
my lord, let my affidavit of service to this
Yes, the
regard.
affidavit of service file be kept with the record.
এই দুটোই আছে।
Any time for the appellant, Malad.
Madam for the respondent claimant.
So the appeal is ready for hearing.
Yes, Malad, my appeal, so far my appeal is concerned, Malad, it doesn't require any hearing, because Malad, what has happened, Malad, the learned tribunal, Malad, decided the issue regarding validity of the driving license in favor of the insurance company. It held that the driver of the offending vehicle did not hold a proper license on the date of accident. But while passing the award, did not give the insurance company an opportunity to pay and recover from the owner. Now, the owner adduced evidence on behalf of the insurance company and admitted that he was not aware whether the driver had a license or not. And considering that, the learned tribunal passed the award. My appeal is concerned to that part only, that to pay and recover from the owner. And so far my learned friend is concerned, he took out an cross objection wherein he has sought to incorporate the amended provisions of the law which he did not do in the claim application.
Anyway, so this is only a limited scope.
My lord.
Yes, let this learned advocates for the parties are present. Paper books have been filed.
Paper books have been filed.
As the paper books have been filed, they let this matter appear on 15/12/2025.
I'm grateful.
My lord, the cross objection is not coming on the list. May it be incorporated to the file.
Yes, let this matter appear along with the cross objection. Give the number of the cross objection.
Yes.
I'm grateful.
Nine.
Yes, 9, the hearing was concluded, but there are several judgments cited by both the parties.
I've differentiated all the judgments.
Yes, you have also.
My lord,
His judgment and my judgment, I have separated them.
Okay, okay.
My lord, my lord. Grateful.
my lord, আমি যে জাজমেন্টের সেটটা দিয়েছি আছে
So have you checked up? Both of you checked up whether your judgments are there or not?
নাহলে দিয়ে দেবো বলো
আবার এখন নতুন করে।
আচ্ছা আছে তো
No, no, that is why I kept it today to clarify and to get it checked.
I have given the 5
Whatever you have given, you just indicate it is given by so and so.
এরকম ভাবে সেট দেওয়া নেই এই সেলাই করে
সেট দেওয়া নেই এই তো ইনকাম আর এটা নিয়তি কুমার কেন এসেছে?
This Reliance Niyati
এটা
Kumari,
থাকার
probably, this is my lord's judgment, so my lord had probably,
এটা থাকার কথা না
এটা নিয়তিটা my lorডের judgment বোধহয়
এটা সরা
একবার ওনাকে দেখিয়ে নিন my lordকে।
দেখে না
No, no, how this judgment has come here? This is already disposed matter.
Yes, yes.
এটা আমাকে দিয়ে দাও
Herein, my lord decided
Father,
40,000 should be
please
given,
compile this
probably
and-
for that, maybe.
এটা খুলে নাও
এটা কি দিচ্ছে আমি তো জানি না।
একই কোম্পানি
Then this way, this should not be allowed, at least when Mr. Bonik is there on the other side, my lord.
already
No, no, no. Whatever he has given, it's there. Now, what is he doing?
এই তো হ্যাঁ
yes compilation এটা এই compilation always
Not
manner
for
she
Sunny.
and manner his manner her senior manner always agree when the claimants by advocate manner agree
And
everything
especially
manner
Mr.
say
No, no, when you are appearing on the side of the claimants, so
I'm not, we never appear.
manner always in every court both of them are submitting that we the claimant advocate are trying to mislead the
no,
court.
but this is a situation is not here, I believe. Maybe other courts, but here I find the situation is different.
My lord, I am my lord on the basis of the authorities.
Anyway, better check it up. Better check it up. Both of you.
Yes,
That is why I kept it today.
everything is there.
Okay, just let me.
Especially if Mr. Bonik is there.
Just a minute. Okay, now this is okay. This is the set
Set.
appellant.
Yes, I've written down
This is your set.
my set.
Very well.
And my
From Pronashiti, okay, this is your set. And this is your set.
Yes.
This is your set.
One is income point. And,
So these two sets.
these two sets.
Okay, so let it be there by.
Respondent.
Actually, at the top, it was not written, filed by Tathagata Boni.
Yes, yes, yes. In one set it was written.
ওইটা লিখিনি
Where is that set gone? Where it was written?
ওইটাতে লেখা নেই
ও
ওই সেটটা গেল কোথায় যেখানে
ওই আসলে
yes one set it is there by তথাগত বণিক
এইটাতে লেখা নেই বলে উনি বুঝতে পারছি
আমাদের যে
Yes, record and order. Learned advocates for the parties are present. The matter was put up today for necessary clarification. As the clarification is obtained, let this matter appear for judgment on 26/11/2025.
Grateful, my lord, deeply obliged.
Item number 11.
But I served to the company, but I find nobody appears. But I have to search not who is appearing, but I have to search for the company who is appearing in the matter.
Yes, Mr. Singh, do you appear for this Oriental Insurance Company?
We will fix it up next week, I'll
So you can take instructions. If somebody is not engaged, you can appear.
I'll see to it that somebody appears. Not necessarily me, but somebody would appear. I'll ask the company to appoint somebody.
Yes, record an order. Learned advocates for the parties are present. As none is present on behalf of the respondent, the matter stands adjourned till 25.
25. On 25, somebody would appear.
25/11/2025.
মঙ্গলবার ঠিক আছে This is my opinion. I'm for the respondent insurer.
It is ready for hearing.
No, the application for condonation of delay. Condonation delay. Application.
Can কত ওটা?
Permanent 6353 of 19.
That is old can.
6353 of 19. One can be covered. এখন করা হবে কারেন্ট অর্ডার তখন তো এরকম ছিল না এখন সিস্টেম যেমন হয়ে গেছে না this is my delay 209 days as per my calculation.
Just a minute. When was the order passed?
Order passed on order to tribunal was on 12th of March 2015.
12th of March 2015.
Lordship.
And
we
how many days?
Applied for the certified copy.
209 days delay, in total the calculation of my learned friend is.
Okay, 209. So as per the reporter, how much is the delay? Anyways, this section 5 application is filed. Certified copy was obtained on
4th of May 15.
Okay. And when did you file?
I filed on 15th of February 16.
Which district?
North 24 Paraganas, Barasat.
Injured. Record and order. Learned advocates for the parties are present. Hard learned advocates for the parties. This is an application for condonation of delay. This application is filed for condoning delay of 209 days in preferring this appeal. Upon considering the petition and upon hearing the learned advocates, this court is of the view that the cause shown is sufficient and the delay should be condoned. Thus, I condone this delay in filing this application. So, let paper books be filed.
By 30 days,
let the respondent, the appellant is permitted to file the paper books on or before 2/1/2026. Let this matter appear on 6/1/2026. Yes, for hearing.
Evidence service may be kept.
Yes, the affidavit of service file be kept with the record.
Oh, bless your lordship.
Yes, can stand disposed.
Praying for not today.
Yes.
Praying for not today.
Okay, not today.
15.
No, 14টা? Oh, 14টা, not this. Yes, 15.
Your Lordship, this is my appeal. Your Lordship, today I am pressing for the stay petition. The appeal has been filed within time. The statutory deposit is there, Your Lordship, of 25,000. Your Lordship, I'm praying for the stay to be interim stay to be given till I deposit the entire sum.
Yes, record an order. Learned advocate for the appellant is present. As the appellant insurance company has deposited the statutory amount, there shall be a stay of operation of the award dated 30th July 2025, passed by learned Additional District Judge, Diamond Harbour, South 24 Parganas, in MSC case number 590 of 2022 for a period of 5 weeks. The appellant insurance company shall take steps to deposit the entire awarded sum along with the interest, excluding the statutory deposit, within this period of 5 weeks. Stop. In the event the awarded sum is deposited within the period of 5 weeks, there shall be a stay of operation of the award dated 30th July 2025, passed by the learned trial court till disposal of this application.
Deeply obliged, Your Lordship. Lordship, direction of a service upon the respondents to be given.
Let copy of this application be served upon the respondents within this period of 5 weeks. Liberty to mention.
Yeah,
16.
509 to FMTMB 509. Take. Your Lordship, this is my appeal, Your Lordship. There are two application, Your Lordship. There's a delay application as well as stay
No,
petition.
delay application has to be served.
I have served. My affidavit service is there, Your Lordship.
How many days delay?
Your Lordship, the delay applicant is CAN 2. Your Lordship, kindly come to the CAN 2 first, Your Lordship. Yes, page.
CAN 2
CAN 2, CAN 2. Your Lordship, the delay is of around 44 days.
Yes.
Huh? CAN 2.
CAN 2 নেই রেকর্ডে? Yes, record an order. Learned advocate for the appellant is present. None appears for the respondents in spite of service of notice. Thus, this application for condonation of delay under Section 5 of the Limitation Act is taken up for consideration. Stop. Heard learned advocate for the appellant peruse the petition filed. Upon perusing the petition and hearing the learned advocates, this court finds that delay of 42 days in preferring this appeal is explained. Thus, the said delay is condoned. The application for condonation of delay stands disposed. The application for stay is taken up for consideration. এটা দেখি পিটিশনটা দেখি
দিলে থাকলে ফ্রি সার্ভিস দিতে হবে যা একদম বাথরুম দিয়ে করে দিল করে নষ্ট নেই কালকে করবো
Yes, the application this is order with CAN 2. No, this is CAN 1. আগেরটা CAN 1, this is CAN.
No, Your Lordship.
Previous one is CAN 2.
Yes, Your Lordship. The
আগেরটা
delay is
CAN
CAN
2
2 and
আছে,
stay is
এবার
CAN
CAN 1. The application for stay filed by the appellant insurance company is taken up for consideration. Stop. It appears that the appellant insurance company has deposited the statutory amount of rupees 25,000. Stop. Thus, there will be a stay of operation of the judgment and award dated 16 June 2025, passed by learned additional district judge, 16th Court Alipur, South 24 Parganas, in MSC case number 15 of 2025 for a period of 5 weeks from date. Stop. The appellant insurance company is directed to take steps to deposit the entire awarded sum along with interest, excluding the statutory deposit, within this period of 5 weeks. Stop. In the event such deposit is made within the period, there shall be a stay of operation of the judgment and award passed by the learned trial court till the disposal of this application. You have served copy of both the applications, stay as well as.
Yes, yes.
Let the affidavit of service file be kept with the record. দুইটা ডিসপোজ, একটা পেন্ডিং থাকছে।
Lordship, this is my appeal, Your Lordship. There's no delay. The appeal is within time. I'm pressing for the stay petition. This is my statutory deposit, Your Lordship.
Yes, record and order. Learned advocate for the appellant is present. As the appellant insurance company has deposited the statutory amount of rupees 25,000, there shall be a stay of operation of the judgment and award dated 25th August 2025, passed by the learned additional district judge, first track 8th Court Alipur, South 24 Parganas, in MSC case number 5 of 2019 for a period of 5 weeks from date. Stop. The appellant insurance company shall take steps to deposit the entire awarded sum along with the interest, excluding the statutory deposit, within the period of 5 weeks. Stop. In the event the deposit is made within the period of 5 weeks, the interim order of stay shall continue till the disposal of this application.
A service order to be given.
Yes.
The service is not given.
Let a copy of this application be served upon the respondents. Liberty to mention.
Lordship, for item number 15, the order, I'm just humbly praying that order to be uploaded by today itself, Your Lordship, because attachment order has already been given. Only item 15 order to be given some priority. For today, it should be uploaded. The bank, otherwise the
item 15 টা তাড়াতাড়ি ইয়ে করে দেবেন, পাঠিয়ে দেবেন।
server.
Shall I give you the liberty to communicate the order?
Yes, Your Lordship. Yes.
Learned advocate is
15. Item
learned
15.
advocate for the appellant is granted liberty to communicate this order.
Server order.
Yes, along with the server copy.
Deeply obliged.
18, I am appearing on behalf of the appellant insurance company, my lord. It's coming up for the first time. My stay application, I have deposited 25,000. This is the copy of the challan. I'm praying for stay, my lord. Interim stay.
Yes.
There is no delay in the matter.
Yes, record and order. Learned advocate for the appellant is present. As the appellant insurance company has deposited the statutory amount of rupees 25,000, there shall be a stay of the judgment and award dated 17th day of June 2025, passed by the learned additional district judge, Second Court Durgapur, Paschim Bardhaman, in MSC case number 157 of 2018 for a period of 5 weeks from date. The appellant insurance company shall take steps to deposit the entire awarded sum along with interest, excluding the statutory amount, within this period of 5 weeks. Stop. In the event such deposit is made within the period, there shall be the interim order of stay shall continue till the disposal of this application. The appellant shall serve copy of this application upon the respondents within 1 week and liberty to mention.
I'm deeply obliged, my lord. Grateful. And the amount has to be invested. Registrar General to invest the amount.
The Registrar General shall invest the sum deposited in a fixed deposit of a nationalized bank and shall renew the same from time to time.
I'm deeply obliged, my lord. Grateful.
Lordship, kindly pass over matter, Miss.
Yes, call the passover matters.
Is online.
My lord, I am for the respondent insurance company for item number 2, my lord.
Yes. Some correction with regard to the name of the claimant.
My lord.
My lord, yes. We have already.
Yes.
There are two appeals. One by the wife of the deceased and another by the parents of the deceased. Parents of the deceased are my client. But my clients got the money.
No, whatever it is, but for the wife of the deceased is concerned, there is dispute with regard to name. So let that be corrected.
Dipti Sharma,
My lord.
sequel has been added. Subsequently married, sequel has been added. So as well, you are corrected.
So you have been served with a copy of this application.
My lord, they have.
Got an order. A application ta din ekটু.
দুই হ্যাঁ আইটেম নাম্বার 2 3 আছে ক্যান 3
Yes, when was this appeal disposed?
Disposed of last 2nd March 2023.
2nd March 2023. Yes, record an order. Learned advocates for the parties are present. This appeal was disposed on 2nd March 2023. Stop. However, due to mistake in the name of the claimants, appellant, the claimant appellant 1, the amount, the awarded sum could not be disbursed. Stop.
Claimant appellant
One.
In FMA number
In FMA 1718.
My lord.
In FMA 1718 could not be disbursed. Application is taken out by the appellant for rectification of her name in the cause title. It is the contention of the appellant that her name is Deepti Shikwal. However, she is using the name Deepti Sharma Shikwal after her marriage.
Yes, lordships.
Upon considering the contention of the petition and upon hearing the learned advocates, this petition stands allowed. Let the awarded sum be disbursed in the name of DWPTI SIKHWAL.
Lordship, bank account also add.
Yes. In the name of Deepti Shikwal. Instead of DWPTI SHARMA within bracket SIKHWAL.
My lord. Must oblige, lord.
I'm grateful, madam.
If necessary, to plain be corrected.
Yes.
If necessary, memo will be corrected.
By the department.
The rectification be made, in last line, the rectification be made by the department in the memo of appeal.
Lordships.
Can তিনটা dispose হয়ে গেল?
Lordship, rest of the application also disposed
Yes.
of. Rest of the application also disposed of. Nothing.
All other interlocutory applications stands disposed.
Lordship, grateful, Lordship.
Not today.
21. No, 20 minutes is my take it out Wednesday.
Yes.
20 minutes.
21 Monday.
20.
Okay. Item 20. Okay, I made it not today.
On Wednesday. I shall
Yes.
on Wednesday.
But he's praying that be fixed on Wednesday. Millet.
Acha, item 20 লিখে নিন তো। Let this
26.
matter appear on
26.
26/11/2025.
Millet 21 is for hearing. Millet, let it also Millet appear on 25th or 26th whenever my learned friend Millet is correct.
Oh, the other matter also he is appearing.
Yes, Millet. So
আচ্ছা, এই 26 টা তো সেম অর্ডার করে দিন।
Millet, no.
Sorry, 21 টাতে।
20.
21 টা হ্যাঁ। তাহলে ওই ডেটে দিয়ে দেবেন 26 তারিখে দুটো ম্যাটারই।
আর একটা বিল অন্য একটা বিল দিয়ে
এটা কোনটা?
এটাই
21.
হ্যাঁ পেপার
তো পেপার বুক ফাইল করে দাও।
মানে কম্বাইন্ড পেপার বুক রাখছে
In 21 and 22.
21 হ্যাঁ 21
No, 21, is there any, apart from this appeal, is there any other cross objection
another appeal is there
in 21? So that has to be recorded.
সেটা তো লিস্টে অ্যাপিয়ার করছে না, বলছো না কেন?
সেটা বড় হয়েছে
আচ্ছা, item 20 টাতে লিখে রাখুন, 20 টাতে let this matter appear on 26/11/2025. 21 টাতে লিখুন, let this matter appear on 26/11/2025 along with
FMAT MV 50 of 24
FMAT MV 50 of
24
2025.
24
FMAT MV
50 of 24
50 of 2024.
Yeah, what are the 50?
Next matter the fix করে নিচ্ছি আমি।
Sorry, but ওটা 4 of 25
Next matter the fix করে নিচ্ছি।
4 of 24 4 of 24
Number 22.
My lord, I am for the respondent insurance company, my lord. On the last occasion, it was heard that ITI student, my lord, may remember.
Yes,
May
so
recollect.
giving some calculation.
No, my lord, the hearing is yet to be concluded. Let the matter be fixed on Monday at any time or Tuesday as my learned friend.
Fixed the hearing on my lord Thursday. That is my lord on 27th.
Okay. Record on order, item 22. Let this matter appear on 27/11/2025 under the same heading.
Specially fixed. My yesterday matter appeared
Acha,
specially.
27/11/2025 under the heading specially fixed matter.
At 2 p.m. my lord.
No, in the morning itself, specially fixed matter.
I'm grateful, my lord.
প্রথম দিকে দিয়ে দেবেন এটাকে। কি না ফার্স্ট হাফে 27/11 এ? না দুটো
I'm
না।
grateful, my lord.
ফার্স্ট হাফ।
And my next matter is analogous matter in the same family. My lord son died.
Item number 22 with 23, it's already written in the list.
Yes, it will appear.
On next Thursday.
Yes.
I'm grateful, my lord.
Yes, call the original side matters.
CRR.
Item number 1.
When I appear for the plaintiff number 2 series, your lordship will kindly take up the last order dated 7 November 2025.
Some clarification is to be given.
Yes, absolutely, my lord. On the last occasion, your lordship was pleased to direct the learned registrar to issue summons upon the witness.
Yes,
But
yes.
in the original site practice, my lord, it is
Subpoena
a
has to be issued.
it's a subpoena which has to be issued. The learned register has asked us to pray before your lordship to just modify that word summons with the word subpoena.
Yes, record an order. The matter is put up for necessary rectification and correction. In the order dated 7 November 2025, paragraph number 6, it is issued, it is directed for issuance of summons upon the register of assurance. However, it is to be rectified as subpoena upon the register of assurance.
For production of document.
Yes, for production of the register containing Arponnama with regard to the present suit property. Stop.
It's a volume.
Whatever it is there,
We'll use that word volume. That's a volume.
whatever is there, the other contents of the order dated 7th November 2025 remain unaltered.
The volume. Grateful. ওইটা নিয়ে করে দাও ঠিক আছে করে দিয়েছে ম্যাম I really
Item number 2. Okay. Item 2. Not today.
Item number 3. Lordship, I am appearing for the defendants. This has come up at my instance.
Item 3.
Item 3. On October 27, my lord has heard this matter at length for about 1 hour. And it was also prayed that may this matter be recorded as part heard. This is the last order.
My lord, I appear for the plaintiffs and may I say this, and I say this with utmost of respect. The jurisdiction presently lies with court number 33.
Question is just a minute.
Jurisdiction change হয়ে গেলে part heard ওই জন্য mention করা part heard হলে
I thought you want to hear it in this court.
হ্যাঁ I want to
So the question is, it was not recorded as part heard.
It was inadvertently not recorded. It was prayed and
actually when matters are heard at length, okay, the court usually hears the matter because it would cause inconvenience to the parties to make the de novo arguments. That is why, but just if the matter commencement of hearing starts, it may not be made part heard also, unless it is recorded as part heard.
That is the reason it was heard at length by your lordship. Then it was also prayed. Lordship agreed that yes, it will be marked as part heard.
If you decide that this court will hear the matter, I will retain it. Otherwise, I'll release it. Whatever you decide.
Kindly, my lord, I leave it at your discretion because other day my learned senior, he opened the arguments, he submitted, and then
exactly that is why I am saying
yes, record an order.
However, my lord, if I may just place it again, it currently lies with Justice Bondapada jurisdiction. I bow down to what my calls for my lord.
As because I heard the matter, but not recorded as part heard.
Yes.
So the suit is ready for arguments.
It is.
Okay. Learned advocates for the parties are present. As the arguments were heard by this court, this court is of the view that this matter is a part heard matter. Let this matter appear on. Yes, when shall I keep it?
Lordship, preferably on 12th December because my learned senior is appearing from Pune.
Okay,
He will come down.
12/2025.
Very great.
For hearing item number 4.
Lord, I am appearing, my lord. I am for the plaintiff. They have made an application on order 7 rule 11 for rejection of the plaint.
Is the application hearing over from the side of the applicant? Defendant?
Yes, we have concluded our submissions in support of our application. I think, my lord, the
Mr. Deb is addressing your lordship.
Lastly, I comment, should be able to try to.
Ma'am, led by Mr. Mitra.
But this is a case where the plaintiff has multiple counsel to argue.
No, no, no.
But
Who are
that-
you?
But that on the last day I started.
You have completed your part probably.
Mr. Mitro has. Let him not interrupt. Let him not interrupt. When he's completed his part, let him sit down. He will get his fees.
No, no,
There's
here
difficulty.
also finished. Mitro finished.
He
I
will
was
get
going to
his
give my
fees. He has
rejoin.
come here for his fees.
So you
He'll
see,
get his-
this is a
Tell him
part
get
of
his name.
matter. It will be taken up on Fridays. But if both of you agree that this court take up this matter, I shall take it up. Otherwise, if both of you have the convenience to move before the regular bench, you can take this matter to the regular bench.
Lordship has determination.
Substantially heard it.
No,
Milord.
you see, because I'll be taking only on Fridays.
Lordship here.
So if you do not have any inconvenience, I shall.
Well, I have full confidence, my lord, kindly take.
We all have, Milord, and to resolve this, Milord, kindly
Anyway,
permit me.
then let him continue.
Yes.
Let him conclude. Let him start and conclude.
But he has started here. One day had finished. One day fully out.
Yes, Mr. Abhrojit Mitro, let his name be recorded. Very important. Let his name be my name, your lordship need not record, but his name is very important to be recorded. Because he is
No, we have to choose. So many mitros are there. We have to choose.
No, you choose Abhrojit Mitro. Yes, today.
No,
He's
you
in
can
dire
choose,
stress.
I am. That I agree with.
Well, let me, Milord.
Yes, please.
Opposition to the Milord. Milord, before I proceed on the last day, Milord, I place before your lordship order 14 rule 2. Now, Milord, I would not trouble your lordship to look into that provision. I would come to that provision later on. Kindly have a look at the two orders, which may have some bearing in the outcome of this application, which is order 7 rule 11. Kindly, Milord, takes up the affidavit in opposition of the defendant number 36.
কোনদিকে দেখছো তুমি? কোনদিকে দেখাচ্ছো? থাকো। কি বলছো?
Milord, I appear on behalf of the defendant number 36,
Bye.
volume 1.
Yes.
Initially, Milord, the suit was in the nature of declaration. Subsequently, pursuant to an order of this honorable court, it was converted to a partition suit. So I also want partition, and I'm opposing this application, though I'm a defendant.
Reflection হচ্ছে।
Now, kindly come to page 24 once, Milord.
Reflection হচ্ছে। Reflection হচ্ছে। I cannot take the reflection.
My lord has got it, page 24. Page 24 of the affidavit filed by my client.
Yes.
Defendant number 36, Jagrit Bhutoria.
Yes. Page 24, yes.
Yes, the order of the division bench, Milord, presided over
Page 24 of the opposition.
page 24 of the opposition, annexure A, opposition filed by my client. There are two volumes,
24.
volume 1.
This is volume 1. Yes, volume 1 only. There is page 24.
Yes, page 24, lordship has got an order.
No, that is page 25.
Huh?
Page
Then Milord,
25.
possibly it's wrongly typed.
27th April 2017.
28th April 2014, Milord.
28th April 2014. Yes, that is page 27.
That is page 27. Then, Milord, it's not been properly paginated. Kindly pardon me, Milord. Kindly permit me to place this order.
Okay. Oh, this is defendant number 36.
অন্য এফিডেভিট বোধহয় চলে গেছে দেখুন আমায় দিন আমি বার করে দিই পাওয়া গেছে
Page number 24. Yes, 28th April 2000 division bench.
Yes. May I, Milord, place this order? Mr. So-and-so represents so-and-so. Mr. So-and-so represent defendant respondent number 28. The other respondents being so-and-so are absent despite service being effected. Kindly ignore this part. The appellant is directed to file requisite number of informal paper books incorporating, or kindly, Milord, ignore this part also. Direction for filing paper book. Then, Milord, next paragraph. Last but one, Milord. Pendency of this appeal would not preclude the appellant from filing a suit for partition as well as praying for appropriate relief in the said suit. So this is the same suit where this application has been filed. Now, after this order, Milord,
Application was filed seeking amendment of the plaint, and that was allowed pursuant to an order dated 27th April 2017. That
Yes.
order lordship would find, I'm sorry for troubling your lordship, at page 19 of the petition. Petition filed by Mr. Mitro's client, my lord, seeking
Page 19.
dismissal of the suit.
No. Page 19 of the petition.
Yes. The order dated 27th April 2017, passed by Justice Sen.
Yes.
Lordship has got this order. May I, my lord, place it? The plaintiff initially has filed a suit for declaration, what I was talking about, my lord, all the properties and assets, including the defendant number 3 to 34 and those mentioned in the schedule being annexure E to the plaint, are the properties and assets belonging to the plaintiff's husband, along with a decree for inquiry and other consequential reliefs. 7, except the defendant number 1 and 2, other defendants are not represented. Mr. So-and-so, learned counsel, appearing on behalf of the defendant number so-and-so, submits that the suit as originally framed is that of a declaration of share, which is now sought to be converted to a partition suit. The plaintiff has changed the frame of the suit on the basis of an observation made by the division bench in an appeal preferred by the plaintiff. Numbers have been mentioned that the pendency of the appeal would not preclude the appellant from filing a suit for partition as well as praying for appropriate relief in the suit. That order I have just now placed before your lordship, the division bench order. Then there cannot be any doubt that by this amendment, the suit would partake the nature and character of the partition suit. The right of the plaintiff to file a partition has not been denied, and on the contrary, observations are very important because no appeal has been preferred against the order, and this has been accepted by all parties. Has not been denied, and on the contrary, is recognized by an order of the division bench dated 28th April 2024, which lordship has seen appearing at page 27 of my opposition. The plaintiff can make necessary and suitable amendment to the existing pleading in order to convert the suit to a partition suit when a reading of the plaint, very important, blood, kindly take note of it, when a reading of the plaint preeminently shows the ascertainment of right of the plaintiff in relation to various properties, treating the said property as that of a joint family property. The defendants have not filed their written statement. No prejudice would be caused to the defendant in the event the amendment is allowed. Under such circumstances, there shall be an order in terms of A to D. The department shall carry out the amendment within 2 weeks from the date. A copy of the amendment shall be served. The formal orders, directions are given. Then the defendant numbers 1 and 2, who are being represented by Mr. Mitro, shall file the written statement within 4 weeks thereafter without prejudice to the rights and contentions in the said application by them for rejection of the other defendants may similarly file their written statement. So by this order, amendment was carried out, the suit was converted, and the court's observations are very important, which has been accepted by the parties.
Hereafter, this application is taken out.
Much later.
After this order.
After this order, practically nothing had happened. No written statement has been filed. Defendant number 1 and 2 today who has come up before this court while filing this application.
Order 7, Rule 11.
Almost after a period of 12 years.
After a period of 12 years.
Suit was filed in 2012 and possibly the application has been filed 2024. After 2025, after a period of 13 years.
The suit being abandoned.
That's right. So after a period of 13 years, all on a sudden, they realize the suit is liable to be dismissed without challenging the order, which records the fact that preeminently exists. And some other things have also been stated. Preeminently shows the ascertainment of right of the plaintiff. So practically by this order, court has accepted and parties have also accepted, this can be converted. Otherwise, appeal could have been filed. It should have been put to rest. However, they chose not to do it, didn't file any written statement. Now this application after a period of 13 years. I will tell you the history why this application has been filed much later. Now today, Lordship will have to see only the, I'm sorry, Mulad.
Yes.
Today, Mulad, the court will have to see only the plaint, Order 7, Rule 11, at best. With the plaint, the documents which have been annexed.
Dispute here is the property of the company, whether is the property of the company is the property of the this parties or not.
What
these individuals or not.
What Mr. Mitro,
That is the bone of contention.
Mode of contention.
Yes.
Now that mode of contention may be a factor to be considered, at the time of trial, unless the defendants satisfy the court.
Whether from the very plain this can be ascertained or not. That is the question.
Absolutely, absolutely.
This with regard to properties, property of the company and property of
prima facie, you have to take it that the averments made in the plaint are true and correct. The moment you invite the court to probe into a matter or to investigate into an affair relating to a pleading, it calls for trial. Matter ends there.
Yes, that is well settled.
The moment you rely on a document trying to controvert an averment made in the plaint, that's trial. Matter ends there. The scope is very limited. Now let kindly seize the plaint. The plaint has been annexed, Miller. Kindly, Miller, permit me to place the plaints, Miller. I will not trouble your lordship to go through the entire plaint, only the relevant paragraphs of the
Rule 11 scope is limited.
Very
within
limited.
Within that.
Very limited.
Say that order. Only thing is some hurdles you have to cross.
Yes. And Miller, the order. কিছু বলতে হবে না শুধু প্লেনটা
No written statement has been filed despite the action. Amendment has been allowed. That the plaint to be.
That is the best one. That is the best one.
Yes.
Now, Millard, kindly, Millard, comes to the plaint, Millard.
I know you learned from your fathers. You also learned from people.
Anyway, please take your seat.
Millard, let us confine ourselves to the. Millard, kindly take note of few paragraphs, Millard. Then I would place those paragraphs. Probably that will settle.
Page 65.
The paragraphs, Millard, of the plaint, which I will be placing.
Yes, yes.
Paragraphs 12 to 15, kindly take note of it. I will place the amended plaint, of course. That amendment has been allowed.
Page 12 to 15, that is.
Paragraphs 12 to 15.
Paragraph 12 to 15.
Kindly take note of it. Paragraphs 40A, B, C, D.
That is page.
Page, Millard, very well. Let me place the plaint then. Kindly come to Millard. Running page 89, paragraph 7 onwards.
Yes.
Lordship has got it. Let me place Millard.
Yes.
Paragraph 7 onwards, Millard. The plaintiff and her husband, both great lovers of music, produced a Bengali film in which the plaintiff playback the songs. He also sponsored 3 music albums, Millard, in which the plaintiff received the awards. Millard, let us not go into that. Paragraph 8. Despite coming from a Bengali family, the plaintiff adopted the culture and living style of Marwari so-and-so Jain family. This also may not be a factor to be considered. Paragraph 9. The family members of the plaintiff's husband, being a very conservative Marwari family, were opposed to such marriage and was not inclined to accept the plaintiff in their household as wife of Arun Kumar Bhutoria. We are concerned about the estate of Arun Kumar Bhutoria, and after he passed away, partition has been sought for. As a result whereof, the husband of the plaintiff compelled to reside with the plaintiff at a rental accommodation situated at 7B Deoda Street. Paragraph 10. In view of the fact that the plaintiff always wanted to reside with the family of the husband as At the request of the plaintiff, the in-laws of the plaintiff and the defendant number 1 also started residing with the plaintiff and her husband at the said premises number so and so. Then the amended portion, paragraph 12A onwards at page 93. Next page, Lordship has got it. Initially, the late Arun Kumar Bhutoria purchased the properties in his own name. Particulars of the properties purchased by late Arun Kumar Bhutoria in his name are as follows. Numbers have been mentioned, A, B, C. Then 12B. The defendant numbers 1, 2, and 38 held shares on behalf of late Arun Kumar Bhutoria. All these persons were employed under the late Arun Kumar Bhutoria. The defendant numbers 38 holds the share of and in the defendant number 14, 20, 23, 24, 26 companies as trustee. May I pause here for a moment, Pulat? Mr. Mithro, while addressing, said when you hold the property in trust, that is something different, and possibly then you can ask for partition. And he explained the effect of holding a property in trust. Now, my lord, to that, my lord, you have to see the entire plaint.
Yes, property held on trust, whether it appears from the plaint.
Now you have to read the entire plaint.
Yes,
yes. Not only one paragraph. You just cannot take out one paragraph or a sentence. You have to read the entire plaint in its entirety to know the case, what has been made out. Because you are deciding prima facie without calling anybody to the box. Such shares were acquired with the funds provided by the late Arun Kumar Bhutoria. Kindly take note of it. And the AK group of companies. Kindly take note of it and kindly mark it. Because there are several companies, different numbers 3 to 34. And partition has been sought for in respect of the said companies relating to the share of Arun Kumar Bhutoria. So how the companies were formed, how the
companies were formed to run a business.
Initially, that gentleman started the business. He started from scratch. He made it. He formed a company. Then several companies were formed.
For the purpose of doing some sort of business?
All his creation. I will go by the plaint only.
Yes, from your case. What is your case?
Several companies were formed.
Yes.
All created by him and all out of his own fund.
And that is continuing. Business is continuing.
Continued.
No.
Today business is continuing.
Yes.
Why the partition? Why the partition has come?
Because
then he passed away.
Formation of a company, purpose of the formation of company, and
all out of his own fund. That is the averment made in the plaint. I will show you from the subsequent paragraphs. Which at this stage, at this juncture, can't be decided. Can't be denied at all also. Because by producing a document, if you say, no, I'm not accepting it, then you call for a trial.
Yes, it is your case also. Companies were formed and for the
all
purpose of business.
By that particular gentleman, Arun Kumar Bhutoria.
He is the sponsorer or he may be the contributor.
Yes, whatever way.
It is your case.
Absolutely.
He has formed the company which
AK
is
group companies.
For the purpose of doing the business.
Yes.
And that business is continuing.
Then he passed away.
Yes.
The heirs, his wife, who is the plaintiff, and the two sons, one is opposing possibly, I do not know whether it's appearing or not, and myself. I am the defendant, have been implemented as defendant. I'm supporting my mother to the extent I also want partition. If it's his creation.
What is your status in the company? Are you holding?
In some of the companies, I am the shareholder.
You are the shareholder?
Yes.
Okay.
After my father passed away.
Now it is the question whether the companies, the other defendants, who are the companies, did they file any written statement or did they come out with this application?
But the principal defendant
this is the bone of contention. This is the companies, but whether the company has raised any objection to the suit.
The person who is contesting
is
Mr. Mitro's client.
Yes.
Defendant number 1 and 2.
An individual.
Private individual. And the brother of Arun Kumar Bhutoria. He doesn't want the properties to be partitioned. He has asked for dismissal of the suit after 12 years. Of course, there is obvious reason for that. Now, the question is at this stage whether that can be entertained or not.
Yes, so 12B.
12B is very important. Shareholders and directors also, I am told. Mother and the son. Plaintiffs, Plaintiff and the defendant number 36, both. Such shares were acquired with the funds provided by the late Arun Kumar Bhattaria and the AK group of companies. I stressed on it, kindly take note of it and mark it, Malad, if possible. Particulars of the shareholding pattern in the defendant numbers 3 to 34 companies, including those held through the defendant number 1, 2, and 38, will appear from a schedule annexed here to and marked with the letter so and so. Then, the premises number 10, Pretoria Street, Calcutta 71, is owned by a trust, namely Educational and Welfare Trust. The defendant number 1 has, however, refused to make over the trust deed or particulars of the present trustees to the said trust. The plaintiff reserves her right to suitably amend the plaint upon a copy of the trust deed or related documents being made over by the defendant to the plaintiff. Then, paragraph 11. Thereafter, out of the said wedlock, the plaintiff and her husband, 2 sons were born on the dates were mentioned. Paragraph 11. Paragraph 12, Milord. Because of the hard work and the sincere endeavor and the efforts made by the plaintiff's husband and the plaintiff, the business of AK Property Consultants extended and flourished, and diversified activities in construction of commercial and residential buildings. From the funds accumulated, kindly take note of it, from the funds accumulated out of the income of AK Property Consultants, diverse companies were promoted, being the defendant number 3 to 34. That is exactly what I had stated, and that has been narrated in paragraph 12. How these companies were formed, how the money came, what was the initial business, who were the persons involved in the business. That's why the partition has been sought for in respect of those companies also. And AK group of companies became a big name in the field of real estate. The assets and capital of the said companies, being the defendant number 3 to 34, were purchased and acquired from the income generated by the plaintiff. Kindly take note of it. And the plaintiff's husband, by the business of AK Properties, gradually became AK group of companies, being a big name in the field of real estate. Now, 12A and C were added pursuant to the amendment, which I had placed prior to placing paragraph 12. Then paragraph 3. Various multi-storied buildings, hotels, shopping malls, projects were being constructed both within and outside West Bengal by the AK group of companies. So prima facie, on a
the
bare...
question is, from the plaintiff itself, did they allege that the suit is barred by law? Barred under the statute?
Plaintiff.
From the other side, that is
they
the
didn't file any written statements of what will they say.
That
their mode of...
That the reliefs claimed is barred under law.
I tell your lordship. Plaintiff files a suit. Plain file, that's the document on the basis of which plaintiff seeks a decree. Now for defendants, they have to come and they have to controvert as what has fallen from your lordship.
The suit is barred under law from the plaintiff itself.
No, nowhere. They have not filed any written statement for the first time.
In Order 7, Rule 11,
Order 7, Rule 11, they have said.
They can show that from the plaintiff itself.
That's right.
That the suit is barred by law.
It can't be shown from the plaintiff itself. That's my mode of contention. You may take 5 points in your application, but you have to substantiate and demonstrate from the plaintiff itself that is barred. Otherwise, if you watch and those argument needs consideration, relying on certain documents, that's a matter of trial. They have said it's barred by the Companies Act. Company can't be partitioned. And there is a clear bar under the Companies Act 2013, 430 probably. No civil suit is maintainable. Bar under Benami Transaction Act. They have said that. They have also said when the properties are being held in trust, can't be partitioned. And they have given an explanation. Now the question is, you have to see from the plaintiff whether that's barred or not. And that barred has to be apparent. And their contention can't be considered at all unless they show it from the plain that it's barred. I may take 100 points, my lord, the suit is barred. But at this stage, Order 7, Rule 11 stage, I have to show from the plain that is barred. The moment you can't show it, then the issues are to be framed. And then comes my lord, order 14 rule 2. At best, on the last day I showed your lordship. When there is a question relating to jurisdiction.
Maintainability.
That's right. You frame an issue on that. At best. I'm saying even that can't be done. No additional preliminary issue is required to be made. Full-fledged trial is required. But at best, if they have a case to argue, then order 14 rule 2, frame a preliminary issue on this point. Because they are inviting the court to investigate into the matter, relying on certain documents. He had handed over certain documents. Now, how those documents will be proved? Will be just because I rely on my suit will be the plaintiff suit will be dismissed. So many things will come, and those things are constituted as facts. And the moment you say it's a fact, the order 14 rule 2, maintainability, preliminary issue.
Maintainability is a mixed question of law and fact.
That's right. Order 14 rule 2 is very clear on this. Either question of jurisdiction, jurisdictional issue, or mixed question of law and fact. First issue, go to box and prove it. Suit can't be dismissed. Then Miller. Paragraph 13, I have placed it. Paragraph 13, the Lordship would find again some of the companies and the properties have been mentioned. Paragraph 13. At page 97. Then again, last subparagraph of page 97, Miller. Kindly see. During the lifetime of the plaintiff's husband, in addition to the aforesaid, the following major projects were on the pipeline, particulars whereof are as follows. You have to read each and every paragraph. And another important thing, Miller, Lordship will consider, it can't be partial rejection is not permissible.
No.
Mr. Mitro has cited a decision, I rely upon that. Even Mr. Obrojit Mitro, my learned senior friend, has also placed a judgment. No, not permissible. Supposing, assuming the best case, a claim is barred. You can't do it piecemeal. Then construction of house in Mizoram, so many projects were forthcoming. Then paragraph 14. In addition to the aforesaid AK group of companies, in addition to aforesaid, AK group of companies also undertook projects for and on behalf of several government and corporate clients. Now, Murat, how this AK group of companies were formed, Lordship has to consider, and this paragraph 14 has to
this is your case.
That's right. Only my case has to be considered, my lord, at this stage. Nothing more and nothing less. My case, only the plaint. And at best, the documents annexed to the plaint. Now, this paragraph 14 has to be read with paragraph 12. Where, my lord, the plaintiff has made an affirmation how this AK group of company was formed. Plaintiff has created. I'm sorry, the plaintiff's late husband. Plaintiff's late husband, Mr. Bhutoria, where the plaintiff's contribution was immense. Out of his own fund. So the 14 has to be read with 12. You can't contradict this by way of an evidence at this stage. Then paragraph 15. The assets and capital of the said companies, being the defendant number 3 to 34, very important, my lord, were purchased and stroke or acquired from the income generated by the plaintiff and the plaintiff's husband with the help of the plaintiff and the plaintiff's husband. Mr. Bhutoria, my lord. By the AK properties gradually become AK group of companies. Again, the question of fund comes. How the companies were formed? If it's out of my fund, I'm entitled to ask for partition. That is well settled, and I will rely upon a division bench judgment. Upon the next page, page 105, upon the defendant number 1 and was made to hold, Lordship has got it, Milord? I'm sorry, Milord.
Yes.
Upon the defendant number 1 and was made to hold the share in the AK group of companies for and on behalf of their minor sons, namely Jagrat Bhutoria and Rajat Bhutoria, respectively, as trustee thereof till they complete their education and join business. So somebody had to hold the property because they were minor. Properties are to be held in trust, and the guardians did it. 19. During this period, in view of the fact that the plaintiff's children were very young and required more attention towards children and proper management of the joint family, the plaintiff, though participated in the business, but devoted more time towards the family affairs at the request of the plaintiff's husband. However, the plaintiff's husband used to have a regular discussion with the plaintiff with regard to the business of the AK group of companies in details, and the plaintiff always gave her advice and ideas so that the AK group of companies can be extended and further flourished. Such advice and stroke or opinion of the plaintiff has always inured to the betterment of the business of AK group of companies. See the contribution and how the fund came. 20. Then with the increased number of the family members, there was a necessity of bigger residential accommodation. Kindly ignore this part. It talks about the residential accommodation. Then the premises number 10 Pretoria Street, Malad, possibly it was a purchase, a bungalow, out of the same fund. Then paragraph 16, very well. Paragraph 16, Lordship would also consider here. Paragraph 16, Lordship would kindly consider how the defendant number 2 has been described, who has been impleaded. The defendant number 1, being the younger brother of the plaintiff's husband, was unemployed and was idle as he was suffering from epilepsy bouts, so that he was not teased and depressed, and to get him settled in the future, at the request and insistence of the plaintiff to her husband, to engage the defendant number 1 in some work of the office so that the defendant number 1 can also stand himself. The plaintiff's husband decided to employ the defendant number 1 in AK group of companies. The plaintiff's husband also allowed one Sandeep Bhutoria, who is the defendant number 2 here, to join in AK group of companies to work with him in his growing business. So it was Arun Bhutoria's business, where they were allowed to participate and to work. One is his brother, the other one may call him as a friend. And the plaintiff and the plaintiff's husband looked after and provided for each of the family members. Then, my lord, it talks about the marriage. Let us not go into that. Then paragraph 21. I placed 20, paragraph 21. Though the shares in some of the companies were held in the name of defendant numbers 1 and the defendant number 2 and 38, however, in reality, kindly take note of it. However, in reality and for all practical purposes, the same belong to the plaintiff's husband, plaintiff, and their 2 children. That's my averment. Possibly here they take a clue of this Benami transaction. Whatever, I will place a judgment on this. But what is my averment? And that has to be taken as true and correct. The same belong to the plaintiff's husband, plaintiff, and their 2 children. Lordship got it. Then, both Anil Bhutoria and Sandeep Bhutoria, being the defendant numbers 1 and 2, worked as employees in AK group of companies. At all material times, AK group was owned by and belonged to, again, the plaintiff's husband and the plaintiff. So you just cannot ignore this averments. You have to take it as true and correct, at this stage at least. Then, at all material times, the defendant number 1 and the defendant number 2 did not have any right over the said shares of the companies and held the same as nominees and as trustee. Thereof, for and on behalf of the 2 minor sons of the plaintiff, namely Jagrit and Rachit, who have now become major, till their joining the business. Despite their joining the business, after demise of their father, let Arun Kumar Vitoria, the defendant number 1, has continued to hold the said shares in his name. So there was a breach which has been committed by the defendant number 1. 23. Though the defendant number 1 was holding the said shares in the said companies, however, it was always understood and made clear between the parties that the defendant number 1 will not acquire any right, title, and interest in the AK group of companies by virtue of such holding of shares in the name of the defendant number 1. and possibly there is a document. I will check it up.
The one issue is the reliefs claimed by you is barred under law. That is one issue.
It's not barred at all.
No.
Yes,
That is their case. And second is whether your suit violates grant of relief in the suit or your contention will violate any provisions of the
Absolutely,
Companies Act.
Absolutely. I will cite a judgment, my lord.
Yes, that is your protection.
No. Yes.
Whether your reliefs claim, your contentions and all these things will amount to violation, any statutory violation of the Companies Law Act.
I got your point.
If you can defend yourself, then very well.
But first of all, I have to
Because
defend.
this is the two scopes. That is your relief is barred under law.
Absolutely.
And your claims will contravene any of the provisions of the Companies Act. That is the two issues.
Now, my lord, may I, my lord, pause here for a moment? Lordship is absolutely correct. Whether a claim is barred by
under
any
statute.
Now, Lordship has to see my all claims.
Exactly.
That is exactly what I tried to impress upon the court, assuming, but I am not admitting, supposing a particular claim, assuming is barred by the law. And if the other claims are entertainable, maintainable, you can't dismiss the suit. You can't. Because it's a suit for partition.
Right.
And this suit for partition was initially not there. It was a declaratory suit. And pursuant to the court's order, which records the fact the averment suit otherwise demonstrate it's a partition. Therefore, amendment was allowed.
Amendment was allowed.
So basically, it put to rest there.
Amendment was allowed upon contest.
Upon contest. So on that basis, on the basis of the observation, when the amendments were carried out, there is no scope for reopening the issue. Because the basis of the amendment was the observation of the court. Court read the plaint.
The other thing is whether any of your contention, any relief will contravene any provisions of the Companies
That I will
Act.
show. My argument is supposing one relief is barred, you can't dismiss the suit. Piecemeal, can't be done. And this question of bar, if it relates to a fact, that also you cannot decide.
No. Bar means what? From the
on
the four corners of the plaint, the suit is
it's not.
Your relief is barred under law.
Absolutely.
Or there is a statutory violation will be there.
Right.
Because these are the two things that the court has
Absolutely.
to see.
Now the question is up to now what I have placed, my lord, from the plain, it would demonstrate that the companies were formed out of the fund of that particular gentleman. So matter ends there. And the partition is permissible. If I can show the companies were formed out of the fund of a particular gentleman, if he creates it, and if he has a substantial stake in the company, if it's his creation, his legacies will not be able to ask for partition if somebody opposes. Certainly they can. And the bar under 430, my lord, of the Companies Act, which has been argued, will not apply at all. That cannot be decided there in the NCLT. For that, a full-fledged suit has to be filed, where an evidence has to be considered. It has to be gone into. That's the difference between a proceeding and a suit.
Yes.
There has to be some difference, my lord, between a suit, which is a full-fledged proceeding. Of course, it's a proceeding, where all things are considered. And most importantly, what you have averred and what somebody has controverted are to be proved by asking the person to go to the box in a simpliciter application. That can't be done. Then paragraph 23, my lord. So kindly consider the averment. I will place the judgment, of course, because these averments have a very, it has a very important bearing, my lord, in the outcome of this application. What have I averred there? Though the defendant number 1 was holding the shares in the said company, however, it was always understood, my lord, I have placed. So I requested your lordship to take note of this. which says out of the fund of that particular gentleman, Mr. Arun Bhutoria. You have to accept is that true and correct. Even if they have some thing to argue to show. At this stage, you can't. Para 24. Then, it would be evident from the said declaration that the defendant number 1 was always a nominee of the late Arun Kumar Bhattaria, held shares and remained in various companies and firms as mentioned in the schedule being annexed herein were formed out of the said out of the said capital and out of the said late Arun Kumar Bhattaria.
Yes.
The defendant number 1, 2, and defendant number 38 have no right, title, and interest on the said properties and stock or assets and wealth or anything whatsoever in the nature of the said firms and companies as mentioned in annexure A. Annexure E is the annexure where all the companies, the particulars were given. So he has averred that this gentleman, they have no interest. And how were they taken, how were they brought in? That has also been averred. Is a mere employee to help them. And all out of my fund. Para 25. However, subsequently it transpired that defendant number 1 had started acting in detrimental to the interest of the plaintiff's husband and claimed right, title, and interest in the properties and shares belonging to the company. Plaintiff.
You're the defendant number 3.
I am the defendant number 36, the son
36, right,
of Arun Bhutoria. Plaintiff is the widow, the wife of Arun Bhutoria. I have been impleaded as defendant number 36. The son, the other son, has also been impleaded. He's defendant number 37, or he's not
contesting.
He's not appearing. And the main contestant, the person who is contesting, is the defendant number 1, the brother of Arun Bhutoria.
Brother of Arun Bhutoria.
And Sandeep Bhutoria. And how were they brought in, I've shown you from the pleading. Obviously, they don't want partition. They have good reasons to stop me from asking for partition.
They have their own shares in the company.
But in some of the companies they have. So far as my averment, if it goes. Right. But the actual fact is, I tell you, Lordship, why this application, Lordship, is asking me, Apart from the suit,
no, I just want to see the status of these parties. One is you.
One is me.
The other is your brother who is not contesting.
He also has some shares in some of the companies. Probably he was made directors. I will take instructions. Some of the companies.
But some of the defendants are
1 and 2. They are. I have made an averment to that effect. And I have said how they were permitted by the plaintiff's husband. And what was the reason for appointing them as directors?
Anyway, because
important factor is the fund.
That's because you see the scope is limited. You have dealt it with in your opposition, all these things.
In my opposition, but ignore my opposition. See the plaint.
The facts, relevant facts have been brought by you in your opposition.
Opposition, but I would request your Lordship, no need to consider, only the plaint.
Yes.
Now, paragraph 34, that is very important. After the demise of the husband, the plaintiff has started attending the office of the late husband, but the defendant number 1 and 2, they are the troublemakers. They are not allowing the properties to be partitioned. After
you have a right of partition, nobody can prevent you.
That's right. That's why I'm before the court.
That is the main thing.
What I can do in a partition suit, Lordship knows it, I will approach.
Your right is being challenged in this application. If you have a right, that has to be
absolutely
respected.
Paragraph 34. After the demise of the husband, the plaintiff has started attending the office of the late husband, but the defendant number 1 and 2, kindly see, my cause of action. The cause of action of the plaintiff, in fact. But the defendant number 1 and 2, acting in collusion and conspiracy with each other, has prevented the plaintiff to participate in the day-to-day activities of the business set up by the plaintiff's husband. All on a sudden, Mr. Arun Bhutoria, my father, my lord, passed away. They took advantage of this position, one of whom is my uncle. Both of us, myself and my brother, were minors. That's why the concept of trust came. Plaintiff, who is being represented by Mr. Mitro, is a widow. Though she participated, she didn't have much knowledge. We can't say she knows everything. Yes, participated, tried to help the husband to proceed further. But this particular gentleman, the defendant number 1, with the help of defendant number 2, they did not allow the legal heirs of the Mr. Arun Kumar Bhutoria to participate. That's the cause of action of the business set up by the plaintiff's husband. The defendant number 1 and the defendant number 2 instructed the office staff not to divulge any information to the plaintiff and to provide or furnish any document particulars relating to the projects handled by the AK group of companies. So read all the paragraphs, my lord, kindly. AK group of companies.
If he had many more years to live, he was settling up. But if he died suddenly, then his wife was already seeing 2 little children, what will she do? Then the Hari Bhutoria, the brother takes control, and he dictates the dictating, and in a way that benefits him. And a lot you see this Hari Bhutoria, the younger brother of Arun Bhutoria, or nobody. Arun Bhutoria, that he admits also the declaration that Arun Bhutoria is all alone. Because the untimely death of the husband, Miller, this is all happening. If he had lived for a few more years and sorted his affairs out, this would not happen. This is what my submission is. Untimely death. Suddenly from the gym he came out, he could have said that. Now, Miller, people are saying he should not go to the gym and overstress. He died in the gym in Park Hotel. Remember the gym, he died there.
Yes.
That advantage is being taken.
Yes, let him continue.
Yes. Because of the community bias, I'm not on that. But she's a Bengali.
But may I put it in a slightly different way? The commencement of the cause of action is when your most trusted person, your own family member, betrays you, takes control of the situation of an untimely death of his elder brother, takes advantage of the position that the 2 sons are minor, and as what has come from Mr. Mitro, the wife comes from a different community. And that's the commencement of the cause of action that has been pleaded here. So will they be thrown out?
Yes.
At this stage in a partition suit? Now, instructed the office and I placed it. The defendant number 2, the cause of action I have placed. Lord, kindly take note of it. Paragraph 34, paragraph 35. The plaintiff has been deliberately ousted from taking in day-to-day administration of the said AK group of companies, and have not been furnished any details particular despite repeated requests. The plaintiff has come to know from the reliable sources that the attempts have been made by the defendant number 1, acting in collusion with the defendant number 2 and his associates, is trying to take full control of the assets. That is also a part of cause of action for filing the suit. What I have said just now. These paragraphs, paragraph 34 onwards, are the cause of action for instituting the suit, for which the court, after seeing this, because these are not the amended paragraphs, court said, yes, this can be converted to a partition suit. There is an element.
Right.
36. On repeated occasions, the plaintiff has requested the defendant number 1 and 2 to provide details of the immovable property. So paragraph 34 to 36, kindly take note of it. This is the cause of action for filing the suit. What it seems and what it appears from the plaint. And also 37. And also
When
37.
you see partition suit, you see, in fact,
The
all
moment
parties
refusal
are,
comes-
all parties are plaintiffs and defendants.
Absolutely interchangeable.
Yes.
Interchangeable.
All parties have their right.
The moment the refusal comes, I come to court.
That is declaration and this partition.
Absolutely, absolutely, my lord. Then paragraph 40.
Court said amended to place the partition and amended it, and now they're saying no. If they didn't like it, they should have gone for a free from that order. So appeal has been filed.
Yes, so 37.
37 is the cause of action. Now I have to, Lordship would consider, my lord, about this thing. Then amended portion. What was amended? 127, paragraph 40A. Paragraph 40A. These were all amended.
So 33 to 30.
33 to
33A and
37 is the
30.
cause of action for
Yes.
instituting the suit.
Amendment means 33A and 33B page.
Yes, yes, 33A. Previously, I placed the paragraph 33 to 37, which according to me, where the cause of action arose for filing the suit. Now, these are the amended paragraphs. Yes, 33A. Kindly consider, my lord. Under these facts and circumstances, now what are these facts and circumstances, my lord? I'm sorry. I've shown your lordship.
Yes.
It shall be evident that the assets and properties mentioned in Schedule E to the plain belongs to late Arun Kumar Bhutoria. After his death.
Yes, which paragraph you're reading?
40A at page 33A. At the top, page 127, running page. Underlined portions are the amended portions. Page 127, Lordship has got it, running page at the top.
127.
Yes. 33A
Yes,
is the, I think, is the internal page of the plate.
Yes, yes, yes. 33A.
Yes. Now, paragraph 40A, Lordship has got. Yes. These three paragraphs are important, whether the suit is maintainable or not on this. Under the facts and circumstances, it shall be evident that the assets and properties mentioned in Schedule E to the plain belongs to the late Arun Kumar Bhutoria. After his death, the said assets and properties had devolved upon the plaintiff and the defendant numbers 35 to 37 having 1/4 share each. So why 1/4 share each? Mother is alive, mother of Arun Kumar Bhutoria, 2 sons and the widow. Each one will get 1/4. Then 40B. The plaintiff states that some of the assets and the properties were in the name of late Arun Kumar Bhutoria, including the shares which were standing in his name in several of the companies which were owned by him. However, some of the properties and shares which have been described in Schedule E were standing in the name of the defendant numbers 1, 2, and 38. And how this has happened, I have shown you from the plaint. And they are holding the same as trustee for the benefit of the heirs of Arun Bhutoria. And to be more precise, my lord, the 2 minor sons, uncle was entrusted. Because the mother, lordship knows not possible. And the widow, though participated. So best person to look after is own brother, who of course subsequently did all the needful things to take control of it. The defendant numbers 1, 2, and 38 were all at material time standing in a fiduciary capacity by reason of the relationship of confidence. What I have narrated, that has been pleaded. Enjoyed by the defendant number 1, 2, and 38 insofar as late Arun Kumar Bhutoria was concerned. The properties which were in the name of defendant number 1, 2, and 38 are all impressed with constructive trust and are held for the benefit of the heirs of Arun Bhutoria. The plaintiff states that several of the properties are standing in the name of defendant number 34. The shares of in the defendant number 3 to 34 were almost to the entirety held by Arun Kumar Bhutoria. Defendant number 1 to 38 by of a cross-holding between the defendant number 3 to 34. The particulars of the sharing of the defendant number 3 to 34 will appear from a schedule which is annexed here to and marked as A2. Therefore, said manner of cross-holding of shares is evidence of the fact that the defendant number 3 to 34 were in control of late Arun Kumar Bhutoria. 33B, my lord, next page. And the persons who were holding shares of the companies in trust and for the benefit of late Arun Kumar Bhutorian after his death for his legal heirs. The several immovable properties standing in the name of defendant number 3 to 34 have all given in Schedule E, in respect of which partition has been sought for. The incorporation of the defendant number 3 to 34 were only to have a corporate will, where the true beneficiaries of the immovable properties was late Arun Kumar Bhutorian. After his death, they stand for the benefit of his legal heirs. Then 40B. In view of the aforesaid, the plaintiff has claimed the rights to the extent of our 1/4 share in the said properties. In any event, in the alternative, the plaintiff is entitled to claim and claims 1/4 right in respect of the equity shares of and in the said defendant number 3 to 30 particulars whereof have been given. Averment, then the right of the plaintiff and the other 3 heirs. What more I will assert at this stage? On the basis of this averment itself, my lord, suit has to go to trial. Then, so how I have claimed partition, in respect of which properties, there is a specific averment, and lordship would take note of it. That has been done by way of an amendment, paragraph 40 A, B, C, D. I have shown you how the companies were formed, paragraph 12 onwards. Kindly take note of it. And also how the cause of action, my lord, arose, paragraph 33 to 37. All you have to take it as true and correct. Then, page 36. A, B, C, last one is D. Lordship has got it. Running page 135, internal page, Lordship. D. The acts and omission as stated herein above of the companies and firms and all the assets and properties are acquired by the plaintiff's husband. So everywhere I have said. And this is a plaint. And you are asking for rejection. Will the court prevent me to prove my case when I have made an averment, an assertion to that effect? My suit will go. Now, you have to show, onus is on you, when you file this application, that on the face of it, prima facie on the basis of averment suit is barred. Where is that? Where is that? Then, my lord, kindly, my lord, I will not trouble your lordship, my lord, the details have been given. Kindly come to page 147. Amendment, this paragraph was amended, 54A. It's a partition suit. 54A. Despite demands, the defendant numbers 35 to 37 have refused to partition the assets and properties. This is also part of cause of action, paragraph 54A, described in the schedule being annexed to E hereof under the influence of the defendant number 1. And he is none other than my uncle. The defendant numbers 35 to 37 have also failed to render true and faithful accounts of the business. In those circumstances, the plaintiff is entitled to a decree for partition of the assets and property described in annexure A hereof, in accordance with the shares of the parties hereof by metes and bounds, or otherwise, as the Honorable Court may deem it fit and proper. So, based on my pleadings, this is what I have averred finally, and kindly, Miller, paragraph 55 also. Paragraph 55. Paragraph 55.
Another issue is, you see, after the shares, assuming what your case is correct, after the declaration of shares and partition of metes and bounds
will be distributed.
You see, no, that is there. So what happens? The company continues. The separate legal entity continues to function.
Only the shareholding pattern will be changed. But you can't say that my suit is not maintainable.
Yes, that's a different issue.
I will show that judgment.
Because declaration and then partition by metes and bounds. The company, the Suits lying in the name of company. It's an admitted position, matter of record.
Suit is not lying in the name of
No,
individual.
no, no, not suit. The property.
Yes.
Immovable property.
Yes.
Lying in the name of the company.
Most properties, because these are the companies were formed by my father.
So if your suit succeeds,
yes,
those properties, all properties are to be partitioned by meets and bounds. But the company, as it's a separate legal entity, continues.
Whatever my father had, I will get it.
That means function of the company is not disrupted. It continues to function.
Yes, yes, yes. And for that, what I will get it, I have to go to box and prove it.
No, yes.
Based on my assertion.
Assuming you suit succeed.
Yes, of course. Then, my lord, paragraph 55. This is also part of cause of action, my lord. The defendants have invaded and tried to invade the valuable right of the plaintiff to enjoy the property as accrued in his favor. The defendants have denied and interested to deny. The lordship knows, my lord, the section 34 comes into play, the specific relief factor. This is the pleading, usual pleading. Declaration and injunction, the usual pleading, it comes, my lord. Now, my lord, kindly sees the prayers, volume 2, initial and amendment. What was initially there, and after amendment, what was brought in? देखा? ये order चाटते देखा लिखा के आगे ना what? Hey, Lordship's volume টা বোধহয় হবে.
Volume 2 of the application.
Yes. See what has been claimed.
The affidavit in opposition. Volume 2 of the application.
Application, the plaint has been annexed.
Volume 2
আমি বার করে দেবো. Where is? Yes. Only add it. How will you say it's barred on the basis on the face of it? Kindly see what is
page 157.
Yes, my lord, 157. Clause 12, leave under clause 12 was sought for order to rule 2 because they have other cause of action. Kindly do not go into that. A decree declaring that all the properties and assets, including the defendant numbers 3 to 34 and those mentioned in the schedule, annexed here to.
So just a minute. Page 157.
Then, my lord, there is some.
There are some amendments.
161. One amendment. I will come to that.
Yes. This is the original plaint.
Original plaint, which was in the nature of declaration.
Yes.
Annexed, being annexed here are the properties and assets belongs to the plaintiff's husband. Then the amended AB kindly comes back to page 159. You have to read all the reliefs. You have to see everything.
Yes, 159.
Decree for partition of the assets and property mentioned in the schedule being annexed hereof among the plaintiff and the defendant numbers 34 in accordance with the share of the said parties as stated in paragraph 48 hereof by meets and bounds or otherwise as the honorable court may deem and fit proper. Then AB. Decree for declaration that the equity shares particulars whereof have been given in schedule A2 hereof are the properties and assets belonging to the plaintiff's husband. Then AC. Decree for partition of the said shares mentioned in schedule A2 hereof amongst the plaintiff and the defendant numbers 35 to 37 in accordance with the shares of the said parties as stated in paragraph 48. Paragraph 48 I have placed particulars given. Then BA. Decree for partition of all the properties and assets of the business as may be found upon inquiry. So the inquiry, something has been left out or some probe is required. Obviously, I ask for an inquiry. And this inquiry is possible finally when the witness goes to the box and the court inquires into the matter. Otherwise, not possible. Then B. Which relief is barred, my lord? Prima facie. At this stage, which claim is barred? B. A decree for inquiry into the properties and assets business of the plaintiff's husband. All based on averment. Lordship might recall. I've shown all the averments, which has not been controverted up till now. No written statement. Even a written statement is filed, court will not consider. Only the plaint. Take it as true and correct and see what have I claimed. B, I have placed C. Decree directing the defendant numbers 1 and 2 to disclose true and faithful accounts. Obviously, if the defendant number 1 is in control, my uncle, and not giving me the accounts, I have asked for inquiry. I have asked him to give a true and faithful accounts. Whatever I am entitled to, I will get it. Then decree for such sum in favor of the plaintiff as may then again this is an inquiry. Then E, kindly see, I have shown you the averment. It's a perpetual injunction. Finally, If it is distributed, obviously the perpetual injunction has to be passed, restraining the others from interfering. And perpetual injunction against whom? The defendant number 1 and 2. Then G, the declaration of the minutes, because 2 documents we have asked for cancellation, delivered up and cancellation. This is all what I have claimed and prayed. Now, my lord, one document I want to show, which I may not. Which document appearing at page 140? Lordship may or may not look into this, but that's on record.
140
of my opposition.
Opposition.
Is it part of the plain? Lordship may or may not.
Yes,
may or
you
may
have
not.
to confine with the plain.
I know.
What
but
they have to do, you have also to do.
Absolutely. It's a declaration. It's a declaration. Kindly take note of it. It's a declaration given by my uncle, the defendant number 1, saying I have no share. Sum and substance of the document is that. It's part of the plain. It's part of the plain.
If
Then
it's part of the plain, definitely.
Yes, page 140. Kindly take note of it.
140.
Yes. It's a declaration given by Anul Kumar Bhutoria.
Page 140.
Of the affidavit of Lordship will take note of it.
No, if it is a part of the plain, I can consider your affidavit. Yes, which page of your affidavit?
It's part of the plain.
Okay.
Only in their application, they have annexed the plain, did not annex the annexures. So I thought it fit to annex this declaration, which was part and parcel of my plaint.
So in affidavit in opposition, which page?
140.
140. Oh, here it is from 141.
Yes, kindly.
Agen volume to din to?
Just take note of
opposition.
it. It's a declaration of
volume.
volume.
Affidavit in opposition, এটা volume, এটা to 2.
Volume 1 ta din. Volume 1 ta.
Defendant number 36. Affidavit in opposition of defendant number 36.
Yes. The relinquishment of his right, whatever he had at all.
Yes, page 140.
Yes, kindly take note of it. I would not place it. Sum and substance is a relinquishment of right by the defendant number 1. Which I relied upon in my plaint, and I have also made an averment.
Yes.
I, Anul Bhutoria, Lordship would find addressing reside. What is the address? He has said sum and substance. I will give a better copy, my lord, on the next day, which says relinquishment of his right. So this is the position. Now, my lord, before I would not be able to conclude. Just one judgment I want to rely upon today.
So continue on the next day.
Very well.
Or you want to continue 2P
Yes.
or 2P?
Any earliest, my lord, because they are enjoying an interim order to the extent it can't.
Anyway, tomorrow on the next Friday at the top.
At the top, my lord. On that day, I would conclude, and of course, I would come up with the written notes. I will rely on 2 judgments.
Conclude on the next day.
Yes, certainly, and I would distinguish the judgment.
Order. Learned advocate for Mr. Deb, learned counsel for defendant number 36, submits but could not conclude his submission. Let this matter appear on
at the top,
28/11/2025 at the top.
Oh, Lordship is taking part at matters only on Fridays.
Fridays.
Very well. On that day, I would come back.
My
I'm
lord,
grateful.
my lord, may I be permitted to mention item number 1? My lord, the subpoena, some corrections were made. My
Please fast in that.
yes, my lord. One more thing what I want to mention, my lord. I inquired the department.
No, Mr. Dotto was there. and
Yes,
that
my
is
lord.
fast.
I understand. I was with him only.
Yes.
My lord, subpoena, I inquired the department regarding the issuance of the subpoena. So some more time may be taken, my lord. So the matter is listed on 20th November 2025. Can it be?
8th November is the date fixed.
Yes, my lord.
On that day, I shall extend it.
Okay, my lord.
Next Friday, I shall extend it on that date.
No, my lord, I am opposing.
As Rupak Ghosh, due to his illness, he has not come to court. That's why I am praying for not.
My lord, tell your lordship knows the matter is pending since long. May I? My lord, I have got certain submissions to make. May I complete my submission?
After Mr.
If
Rupak Ghosh's submission, you have to make your submission.
Yes, my lord, whatever Mr. Ghosh has also made substantial submissions. All the parties have made substantial submissions. My lord, whatever Mr. Ghosh adds, I will deal it in the written notes. My lord, may I complete my submission? Because I'll tell you, lordship, the personal difficulty. My learned junior, he's getting married. He'll not be able to come next Friday. So, my lord, I was wanting to say.
I can do one thing. I can keep it
in between,
If-
from
if
Monday
that-
to
If that is so, my lord,
Monday
your
to
lordship
Thursday, I
kindly-
can keep it.
If that is so, your lordship kindly. keep
That much I
sometime-
can do.
I'm deeply obliged.
সিদ্ধার্থ বাবুকে ডাকুন তো একটু।
If it can be done within Monday and Wednesday, my lord.
Yes, yes, let me
If it
see
is,
that.
if it is possible. I usually don't stand in the way, but
পরে
this
দেখুন
is such
তো,
a long
এই
matter.
দুটোর সময় কি কোনো ফিক্স ম্যাটার আছে কিনা, মঙ্গলবার কি বুধবারে দুটো কি তিনটের সময়, মঙ্গলবার দুটোর সময় দেখুন তো। Yes.
Great.
Lordship, item number 6 and
Yes,
7.
your matter, I'll take it up at 2 p.m.
Lordship, at 2 p.m. Lordship, Lordship, indisposed
Just a
for
minute, just a minute.
Lordship.
Just a minute. Learned advocates, for the parties are present on the prayer of learned advocates. The matter is adjourned till 25/11/2025 at 2 p.m.
At 2 p.m.
Get. এটা এই কত নম্বর, এটা তো এই
This is 5, my lord.
item number 5.
And ours is 6 and 7.
Yes, 6 and 7. 2 p.m. you have some difficulties.
Lordship, I have some personal difficulty, my lord. I'll be.
My lord, I am for
Make
the
it not today, I shall take it up next Friday. That
Either
much I
next
can
Friday
do.
or Lordship may fix it any next week if.
No,
like
if you have some difficulty, I'll keep it up on next Friday.
Very well.
Yes, what do you say?
Let it retain its position.
No, my lord, I'm in the previous matter, my lord, I'm extremely, apologetic. My lord, an argument has been fixed by two on Tuesday. Can it be on Wednesday, my lord, this matter? On Tuesday, on Wednesday.
এই 26 তারিখে দেখুন তো কোনো ফিক্সড আছে কি? 26 তারিখে দুটোর সময়, মনে হয় 3টের সময় একটা ম্যাটার ফিক্সড আছে।
Can we come then on Tuesday?
না টিউসডে করো, ফ্রাইডে করো না।
আমি তো বলবো তোর কি নেক্সট ফ্রাইডে
না, আমার জুনিয়র থাক। We'll keep it at 3 p.m. I'll finish the argument and come.
Whether you're
Yes, I don't know whether.
there will be some uncertainty. You can take a chance. I can keep it at 3 p.m. on 25th. That much I can do.
Your lordship will kindly do that. Your lordship will kindly do that.
Okay, 25th এ ওই যে 5 নম্বর আইটেমটা, ওই যে 25/11/2025 instead of 2 p.m. let it be 3 p.m.
I'm obliged. I'll complete my
In
argument.
that
there and
case,
I'll come.
maybe come at 2 p.m. since.
My lord would kindly keep it, for the defense, my lord, subject to my lord's convenience if it's Friday.
Which one? That Bhutoria matter?
Yes, yes.
Lordship 6 and 7.
My lord's pleasure was to keep it on Friday.
Friday at 2 p.m. I can do that. That much I can do.
But since
No, I
2 p.m.
taking up at
Mr. Ghosh has that slot has opened up. I was very greedy
because
to.
usually the other matter will continue. In the first half, it will continue. No, if you have some urgency, I can keep it up at 2 p.m. You see, on
Very well, keep
My
it
lord-
on Friday, my lord. But today,
yes, Mr. Bose.
Yes.
Friday
কি হলো? দুটোর
আজকে দুটোর সময় থাকবো না কোর্টে।
তোর না আমারও তো আছে
হ্যাঁ।
মানে নেক্সট ফ্রাইডে
দুটোর সময়।
না নেক্সট ফ্রাইডে there is some difficulty instead of a Friday can it be some other day
Then my lord, Tuesday keeps it,
Yes,
my lord, at
okay.
2 p.m. my lord.
whenever
I shall take half an hour, my lord.
Otherwise,
I
if
have-
you are comfortable to do it before the regular bench, take some more time. I can release the matter also.
No. Lordship has heard it, Lordship, substantially.
Because there you will get all
I
the
have
throughout the week.
I have argued almost. I need half an hour of argument which is left.
Acha, learned advocates for the parties are present.
except
This is
next Friday
item number 6 and 7.
Lordship.
On the prayer of the learned advocates, the matter stands adjourned till
25th at 2, my lord.
আচ্ছা 26 তারিখে দেখুন তো দুটোর সময় আছে কিছু ফিক্স 26 তারিখে বা 25 তারিখেও দেখতে পারেন 25 তারিখে তো একটা তিনটে ওর তিনটে সময়
Any day, Lordship pleases. Any day, Lordship.
But in both the days, there are matters fixed at 3 p.m.
তুমি কার ওলিয়া জুনিয়র
I'll be.
ও তাহলে বলো
If Lordship keeps at 2:30, I'll be finishing in half an hour.
25
Malad, in this matter, Mr. Riju Ghosal is also appearing.
My junior, so what? He said 26
he's
will be better?
Yes.
That's what my lord is asking, so 26.
Okay, তাহলে learned advocates for the parties are
আমি
present
ভাবছি
on the
ওই
prayer
দিকে
of
তার
learned
হচ্ছে
advocates.
তার junior
The
তো
matter
জানে না।
stands adjourned till 26 uh,
November.
11 2025 at 2 p.m.
Lordship. I'm grateful.
At 2 p.m.
Didi.